and we had a viable timber industry at that time. So the language was modified by unreasonable when it came to depletion of natural resources. I live in a wooden house, and I worked as a choker setter in the woods. So there was no intention to preclude industry, but it mandated the legislature to prevent unreasonable depletion. And we trusted the legislature to do what was right for the people. They were the elected representatives of the people. And we wanted to be certain that they knew as a constitutional provision that they better do what the Constitution dictates, and that's not enact anything that was unreasonable with respect to depletion. Now that same unreasonable did not modify the previous phrase with respect to degradation of the environment, which was air, water, and land. We didn't want any more pollution like the Butte mines. Didn't want any more Red River. The Red River is what we used to call that body of water out here that now has trout in it, the Clark Fork River. When I was in high school in Anaconda, we called it the Red River as it poured out of the smelter and the mines in Butte. I tipped a boat over once with my cousin duck hunting, and my watch stopped the next day. I took it down to the jeweler. I went back a couple days later to pick up the watch. The jeweler looked at me and said, "CB, the insides of your watch have been dissolved." And that condition existed for a whole lot of years. And the constitutional provision about a clean and healthful environment, I'm still not sure that that's better than a quality environment. But nevertheless, we expected the legislature to do something about it, not shut down the mines, but make them run it clean. Not shut down the forestry, because I hunt the clear cuts too, and I know the elk like to go where clear cuts are because the harvesting of the timber is a renewable resource, and cutting down a tree so CB can live in a wooden house is not an unreasonable depletion of the natural resource.
I would like to speak to
Okay, and then to Arlyne.
My husband was a hunter and fisherman, so I'm empathetic towards Joe's viewpoints. Those things are important, but when we met as delegates, what we were thinking about, what had happened to Montana from the very beginning, from the time Lewis and Clark came here. And we had read about the copper barons, and one of my favorite books, I don't know if many of you have seen it, The Devil Learns to Vote. I mean, it was about the corporations and what they were doing to the state. And so our primary goal was to handle what CB was talking about, the general pollution of the things that were happening. We don't want that to happen in our beautiful state. And I think our Constitution, attested to by the Supreme Court case with the arsenic in the Blackfoot River, it's proving itself. We had to have some kind of protection. And it's nice to depend on the legislature, but having been there, I can't, oh, they made some big mistakes. I could talk about the re-regulation, but I don't want to get into that.
So I think with that, if it's all right with the conversationalists, we'll expand to the audience. Oh, great. Okay, so I will go in the order that I saw. I saw Professor Cross. Not that Montana Law School wants to dominate, but Professor Johnstone, and then, sir, what is your name? Okay, and then back in the back. Okay, so we'll move it along. Professor Cross.
This is a question for Joe, but the whole panel. And let me tell you first, I very much appreciate your presentation. It was just quite wonderful, and you condensed it in a wonderful way. Let me bracket off, though, from the other types of entitlements you talked about, and I'm not even sure I characterize the right to a clean and healthful environment as an entitlement to start with. But if you take a look at a lot of the responsible thinking that went into environmental provisions, whether in federal law, state constitution, the type of thinking that drove environmentalism and environmental law and these types of laws is that for quite a while, development has been getting a free lunch. and that in terms of the costs, and Montanans know the costs all too well of unregulated environment degradation. The thinking of even fairly conservative economists like Jared Diamond, who wrote a book called Collapse, talked about the environmental collapse of the Midway Valley, is that development should incorporate the cost. You should have the opposite side of benefit. If you get a benefit, you should pay the cost, and the cost should be internalized into the development model rather than just purely the private cost. For far too long in the American West, particularly in Montana, developers have been socializing essentially their private costs. Very recently, in terms of our history, environmental law tried to even that up by saying the polluter should pay. If you want a simple formula, development should pay its way. You should no longer socialize the cost of development, fatten the corporations, by having the people pay for these external environmental costs. Why isn't that a good argument? Why shouldn't there be a right to environment? I mean, if there weren't limits on clear cuts, you wouldn't have your elk at all. If there weren't regulations in the Forest Service, you wouldn't have your bow hunting recreation at all. Recreation is another resource that has to be husbanded and managed, just like development has to be managed. Why is that a reasonable argument that there should be this type of right? The polluter should pay. Development should pay its fair share of the costs of their benefits. And if necessary, should be a constitution, should be the judiciary, should be the legislature, should be citizens to enforce it. What's wrong with that? Let's not talk about other types of entitlement rights or transfer.
Okay.
Just that, why not?
Okay, there is not a single point that I disagree with in your statement, except the very last phrase. I agree with what Carl said last night, Carl Graham, that all these externalities should be costed into the product. And a business is only viable if it includes all of its costs and pays for all of its costs and does not socialize its costs, as you talked about. The very last phrase where you said constitutionally, again, we all want to protect the environment. And I agree that we must have regulation that forces these companies to do it right and to pay the burden of the costs themselves and to not socialize those costs off onto the rest of us. The whole question is whether that protection of the environment should be done constitutionally or statutorily by legislative action. And that's where I believe the Conton erred. They should not have put a provision like this in the Constitution because it creates a legal quagmire that in effect shuts down enterprise, or can shut down enterprise entirely, and can even have negative consequences to, again, even bull hunting implicates the environment. So that's the whole question. Should it be done statutorily or constitutionally?
Okay, just going in the original order, I'll go to Anthony, and Anthony, I'd like for you to sort of keep it short if possible.
Yeah, I guess two questions for the entire panel that are linked. An argument that we're seeing is that if the clean and healthful environment provisions mean anything, if the non-degradation standard written into the Constitution and announced by the court in MEIC means anything, something like the development of the Otter Creek coal tracks, given global warming, would clearly be unconstitutional. And so I'd like you to address whether you agree with those arguments. And then the second side, if that's a bad idea, and as Senator Balyeat says, if it really is a problem to have these rights in the Constitution, we can take it out of there with a simple majority vote. So then why don't we do that?
Judge, did you want to go first on that one?
Did I want to? I gladly will, David. Any assignment you give me. I go back to the basic tenor of the entire convention was that all of the delegates trusted the legislature to do what's right. And you will find in the language, the legislature shall provide adequate remedies. Now, if the particular development that you referred to requires the very best that industry can propose, has available to protect the environment, then there's nothing in here that prevents that. Absolutely nothing. As long as the environment is protected. Now, that isn't prohibitive. That doesn't mean you can't develop. It does suggest strongly that the legislature will pass laws that will say if such and such type of technology is available to do it in the very best, cleanest manner possible, that ought to be required. But it doesn't say you can't do it.
Any other panelists?
Having served in both the Constitutional Convention and the legislature, I know that what we did in the Constitution is basic and stands the test of time. And as far as the legislature is concerned, when you do things statutorily, they can be in effect 1 year, and then the next session, you can get rid of them. So I just really don't depend on doing things statutorily as that affect the environment. The environment was so important that, as C.B. alluded to in his opening remarks, originally that committee was called Agriculture, Natural Resources, or Natural Resources and Agriculture. Somewhere along the line, agriculture, as he mentioned, was dropped, and natural resources isn't even first in that article. The environment was so important to us as delegates that the Article 9 is environment and natural resources. And I think the constitutional protection is important. Whether it's implemented, it took a long time for this Supreme Court case with MEIC versus DEQ, and that was only after the legislature had passed a bill saying that gold mining company can do that because it's not going to affect anyone directly. People aren't going to have standing to do anything because nobody's been hurt. But the point that the Supreme Court made was, you don't have to be hurt. People don't have to die. And wildlife doesn't have to die before action can be taken. That's why I think this environment article is one of the most important in our Constitution.
Dean, I'd like to make one other observation in response to a comment made by Senator Joe. He said that this should be in the legislature rather than in the Constitution. During the Constitutional Convention, almost without exception, when a delegate proposal was being debated on the floor, if somebody was in favor of it, it was constitutional and should be included in the Constitution. If you were opposed to it, it was legislative and should be left up to the legislature and out of the Constitution.
These questions, and you'll get to say what you want. I have to observe it's somewhat, Judge, like the American people. They always seem to agree with the person who's speaking about them. So let's go on to our next question, and I think Senator Balyeat, if you don't get the point and you want to make now, we'll be sure to get it at the very end. So, gentleman down front.
I'm a lawyer, so I'm still begging to hear the answer to the question, is this self-executing or not? In other words, do we entrust judges to make the basic fact-finding and legal decisions under this article, or do we say, no, it's strictly for the legislature to fill in the blanks? And I'm not sure I've heard the answer to it. So, and although I'm a lawyer, that doesn't mean I'm biased in favor of judges. In fact, a priori, we lose half our cases. And even the ones we win, we don't particularly like the decisions a lot of the time. So, having said that, I guess I'd Socratically pose the question this way. As I read the Constitution, and not getting into the lengthy recitation of the con that was recited in the MEIC case, but just reading the plain language of it, it sounds to me like the first punt was in subsections 1 and 2 that the Constitutional Convention was saying, okay,